their commentary on ESI evidence and admissibility. And it's relatively new, 2008. Not a whole lot of issues have come up since then. So that's a great resource. And then there's an article in the Review of Litigation, which is a great, really practical law journal from the University of Texas. And I don't just say that because they also publish one of my articles. But this one is on the admissibility of electronic evidence. That entire journal is geared towards practitioners. So a lot of law review articles, are geared towards academics or judges. These are geared towards practitioners, and that would include the admissibility of electronic evidence, which was published in 2009. Generally speaking, the issues that you're going to run into are 401 and 402 evidentiary issues, relevance. That's a big one. You're going to run into proper authentication, probably more often than not. Where did you get the information? Has it changed? Is it in the same condition? Who had access to it? All of those kinds of issues are going to be a problem. Hearsay and the exceptions to hearsay are going to be a big problem. Original writing rules. So best evidence rules 1001 through 1008, and then 403 balancing. There are lots of unfair prejudice issues dealing with electronic evidence, especially if it's not handled appropriately. It's going to be very easy to argue that the probative value is substantially outweighed by the risk of unfair prejudice, waste of time, confusion of the jury, misleading the jury, those kinds of things when it comes to e-discovery if you're not handling the evidence particularly well. So those are just generally the issues to look out for. I would say authentication is the big one. But be cautious because that's a whole area of practice that I think somebody could specialize in, the admissibility of electronic evidence. In any event, this is my summary. Institute a solid litigation hold and monitor your client's evidence. So make sure they're preserving what they need to preserve, make sure they're not altering the data, and make sure that they're not getting data from places that they're not supposed to be getting it from. You are the first line of defense against sanctions. You are also the first line of offense for the court. So when sanctions are being enforced, they're going against attorneys first. Keep your formal discovery request tailored. Keep all your discovery requests tailored. I cannot tell you how irritated I get when I see boilerplate interrogatories and requests for production of documents. But this is particularly important in electronic cases. They have to be tailored. Anything that could be construed as a fishing expedition is going to be objectionable, and it's going to be sustained. And you're going to have a heck of a time getting any of that information compelled from the court. If discovery becomes adversarial, consider a discovery referee. We like referees in matrimonial cases, so why not use one for discovery? Courts have been very willing to appoint discovery referees in all kinds of cases, including family law, and specifically that was one of the pieces of practical relief that the parties were given in the Schreiber case that we talked about before. So if you think you're going to have a problem, think about protective orders, and think about asking the court to assign a discovery referee. That would save the parties from needing to hire experts. It could also alleviate some other cost-related types of issues. So thank you. Okay, questions? Yeah.
Excuse me. Hello, excuse me. Since they're loud over there, can you stand up with your questions? Everybody can hear you.
Bob, he's all appearing on my own behalf. Facebook recently instituted a new system where you can essentially back up your entire profile history and everything you've ever done in a single file.
Yep.
Really easy. Is that something that would be subject to a discovery request, or after that, is that not narrowly tailored?
I think it would be narrowly tailored as long as you laid the foundation for that. So you'd have to ask them, are you aware that this backup procedure exists? Have you ever done it? When did you do it? And then in turn ask for, okay, well they said that they backed it up in September, so I want that September backup file. And I think that that would be tailored enough, especially because, you know, there's a lot of stuff on Facebook that people can have extensive information, but it's not so broad as it would be like to ask for somebody's hard drive. That's a phishing expedition. A Facebook profile, I think, is a little bit more narrowly tailored in and of itself. So I think if you laid the foundation for getting that entire backup, that would be narrowly tailored enough, but that's just my opinion.
And the other one